Litigation, there's lots of attorneys and lots of specialties. Litigation is the process of taking someone to court. In some cases it's criminal, and mostly the government officials handle that. And then the rest of them are civil. Anytime you're seeking money or trying to get somebody to do something or stop doing something, you do that through civil litigation. What that means for you is you hire a lawyer who basically puts your case together. He's not supposed to be objective. He's not supposed to be in the middle or neutral. He's supposed to represent you. And the other side does the same. And then there's the judge, who is the one person who's supposed to be objective and neutral in all this. The litigation process goes in stages, and it really begins before you go to court. When people come in, I always make an effort first to settle with the other side. It's always a win-win if you can get any kind of reasonable settlement, because litigation is such an arduous process that if you can settle, and maybe both sides don't feel like a win, but they don't feel like they've lost, it's usually a good thing to pursue. Most lawyers will do that. But most cases don't settle for whatever reason. Maybe the other side doesn't really believe you're serious yet. Maybe they just personally don't like each other. The emotions haven't subsided yet. But one way there, eventually you get to a point where the superior person bringing the suit files what's called a complaint. It might be justice court or superior court. On another tape, we'll talk about the difference in those. But let's say we're going to superior court, they'll file a complaint. Then it has to be taken out and served on whoever it is you're suing. Try and do it personally. If you can't, there's some alternative ways to serve. If you're in Arizona, then you have 20 days to come back and answer. If you're out of state, it's 30. So the person being sued does their answer, where they're basically doing that. They're answering all the allegations that the original party put in their complaint. And that basically sets the parameters of the lawsuit, the complaint and the answer. It's followed by a series of steps. The first one is called disclosure, where both sides, approximately 40 days after that last answer was filed, have to submit what's called a Rule 26.1 disclosure, where basically both sides are required to put their whole case on the table, their facts, their law, their witnesses, their exhibits, their experts, everything. The objective was, when that was enacted, the objective was to avoid hardball litigation, and making people spend lots of money to get to the facts. It hasn't really had much luck, but that's the intention. The disclosure process is then followed by what's called a discovery process. This is where both sides will use a series of tools. Request for admission, where you make a statement and ask the other side to admit or deny. Interrogatories, which are written questions to the other side. Request for production of documents, where you identify the documents you want the other side to produce. And those leading to depositions, where a witness is called in, put under oath, and asks questions. Which is a very valuable tool towards trial. That's followed by a period during which both sides would probably try to end the case with motions beforehand, saying basically the other side doesn't have enough case to go to a jury. If those are denied, then you go to a jury. Or a trial. There are a number of steps prior to the trial, but the trial is held. The fact finder, which is either a jury or the judge, makes their determination, at which point the losing side can decide to appeal, go on to the Court of Appeals, or leave it there. That's a very bare skeleton description of the litigation process, but that's basically what happens.